Bombay High Court that happened today, making significant observations and posing tough questions to the government over its proposed fact-check unit. The Bombay High Court asked the centre how can it be the arbiter of fake and false news. Hearing a clutch of petitions challenging the 2023 amendment to the IT rules, empowering the central government to identify fake news about itself on social media, the court said that identification of news as fake and false is subjective and that everyone can have a view and the centre's view cannot allowed to be the final view. The court heard these arguments made by the centre through Solicitor General Tushar Mehta, who said that there has to be a mechanism in place to deal with fake news. He also said that there needs to be a distinction between criticism, humour and parody. The Solicitor General claimed that the fact-check unit will not check whether someone's sarcasm was in good taste or not, nor does it have anything to do with politics and views and expression of opinion. My colleague Radhika joins us for more on this. Radhika, this of course has been a contentious issue, that of fake news and false information on social media and other online platforms. And of course, the Bombay High Court has expressed its concern now, saying that this needs to be, regularized and monitored, and there needs to be a mechanism in place to check that, along with the fact that the centre's view cannot be the final view in matters such as these.
Certainly, various significant observations has been made by the Bombay High Court today. It was continuing to hear a batch of petitions that were filed by a bunch of people, in fact, over the last several months as far as the fact-check unit of the government is concerned. These are petitions challenging the fact-check unit. As far as today's proceedings go, Solicitor General Tushar Mehta for the first time started arguing in this matter, and he started by speaking about the vast expanse of internet and how it is deregularized and so on, and therefore there needs to be better guidelines that have been brought in to sort of regularize the internet, and which is what the fact-check unit is attempting to do. When the court put forward certain pertinent questions such as how can government be the arbiter of fake or false news, how can you define what is fake or what is false information, can also be sort of said as a fact and can be opinion as well. So would you put some sort of limitation in that, and you have a view, I have a different view, how can your view be better than mine? So these are some of the questions put forward by the court, to which SG did say that we are not speaking about views or opinions here. We are not talking about satire, humor, jokes. We are very specifically talking about government schemes, business of government, and perhaps announcements of the government, and nowhere are we going to sort of govern what even the Prime Minister says or what group of ministers say. So therefore it is solely to do with the business of the government, facts of the business of the government, statistics or information with respect to what the government schemes are about or the announcements and so on, and does not speak about views and opinions. So that's what SG Tushar Mehta said before the court, that it is not going to go in the way of any of parody creators and so on, and it is all got to do with facts, and that's about it. And then, of course, the court asked about the role of intermediary. Somewhere, the role of the intermediary also comes into play, where, just to be specific about what the court has said, in fact, SG had said that while right to receive correct information is a fundamental right, none can claim the same on spreading of false news. High Court also sought to know on the intermediary, because Tushar Mehta, the Solicitor General, in fact, went on to say that they had the option of doing nothing after receiving some sort of communication from FCU on posts flagged by it as fake, false or misleading. So therefore, what about this amendment then? If they had no role, and if they say that they will choose not to do, let's say for Twitter, for instance, if they choose not to do, then what next? Then, of course, the legal recourse is something that the centre will go for. So a lot of clarity once again being sought by the court as far as the specific provisions are concerned, as far as the difference between facts and information is concerned, facts and opinion is concerned. What is, opinion for others may be fact for you as a government, officer or as a government department. So how does one differentiate that? So all these pertinent questions being asked, and of course SG stating that some of the questions need to be clarified from its own department, and therefore the arguments will continue tomorrow.
All right, Radhika, thank you very much for joining us with those details. So the grey area of internet and online platforms need to be regulated. That's what the court has said. And of course, we'll have to see what comes of that hearing when it